independence constitution, although it created for a high court, the mode of appointment of the high court was by the Governor General at the first instance, and after self-government, the President of the Republic was the appointer of judges. So that because all persons employed in public service were serving at the pleasure of the appointer, it is quite clear that there was a relationship, a very closely knit relationship between the appointer, the executive or the president, and the appointed person who was a judge or the Chief Justice. That relationship pertained throughout all the way under the old constitution up to 2010.
We were an appendage. The judiciary was a department in the Attorney General chambers. So ideally then, it was part of the executive. And there were many instances where the executive would direct judges and magistrates on what to do. So we were not an independent institution. So if you are a judge or magistrate who was independent, you are an exception rather than the rule.
In every conceivable way, the judiciary was systematically neglected. I call what existed in the judiciary designed dysfunctionality. It was designed dysfunctionality because the judiciary was not supposed to be efficient, and it was not supposed to be effective, and it was not supposed to be facilitated, and it was not supposed to have resources to do its work. If it doesn't have all those things, then it will be impossible for such a judiciary to assert its own independence. Then it will become a judiciary then that is subservient, literally, to the executive and to other political forces. And I think that's what we saw in the pre-2010 judiciary.
With the advent of the Constitution 2010, all that changed, so that we now have three clearly established arms of government. And if you look at the provisions of the Constitution Article 2, you'll find quite clearly it is stated that the executive, the legislature, and the judiciary are established as organs, state organs, which derive their authority from the people. And so the people are at the paramount position. The judiciary is given authority as an organ of state to exercise judicial authority, which emanates from the people and invests or vests in the judiciary, and to do so without any reference or direction by a third party, by any other organ or authority. And so you can see just from the Constitution itself as an instrument, there is an absolute separation of the powers of the three organs of state. Since the transformation framework came into place, there was the need for us to robustly, as a judiciary, assert that independence, because failure to do so would mean that we would easily revert back to the old position, which was the easier and more easily understood position to fall back into. And some of the things that the judiciary has done has been to try and assert its jurisprudential independence, or independence from a jurisprudential point of view, but also from a point of view of managing its finances. So we have requested, as a judiciary, far more funds than have ever been requested in the past to run the judiciary. So these are some of the things that we've done in terms of securing a robust independence. There has been the jurisprudential aspect, there's been the financial aspect, there's been the growth of the courts and in managing its own affairs outside of the support of, outside of the direct engagement and involvement of the central government. So for example, we do our own buildings now. We used to rely entirely on the Ministry of Public Works, but now we do our own bills of quantities, we prepare our own designs, and we supervise our buildings.
It begins with the Judicial Transformation Framework, which in key result area number 2 announces that the judiciary will, even while it is robustly asserting its independence, will constructively engage with the other arms of government as well as with other stakeholders. So that became a principle upon which conversations could begin. It was, I think, previously, the judiciary feared having this kind of interactions with other arms of government because of the fear that it will be deemed to be subservient. And there's something valid about that anxiety. But once stated in this way, then it is understood that there are two sides to it. There must be constructive engagement, but at the same time, that engagement must respect the independence of the judiciary, hence the need for it to be structured. The National Council for Administration of Justice is chaired by the Chief Justice, and among its members are all the heads of all the arms that have anything to do with law and order. So the Attorney General sits in the Council for Administration of Justice, the Inspector General of Police sits, the Director of Public Prosecutions sits in the Council, the Director General of Prisons sits in the Council, civil society members sit in that council, the Kenya Law Reform sits in that council, and so forth and so forth. So that is a clear statutory a blessing to the idea that these arms of government can actually come together and deal with problems facing the administration of justice in a constructive manner.
Another point at which we have had discussions with other arms of government was the situation when Al-Shabaab was really very active in the country, and the national security organs of the state, including the executive and also parliament, were very concerned that in many cases some of the accused persons were being released on bail and so on and so forth, and they felt that the courts were running in an opposite direction from what the national policy ought to have been in terms of the security of the state. And so we had a meeting with the members of the National Security Agency. We had a number of exchanges at the Judiciary Training Institute, where we had colloquia and workshops with them. And we were able to understand from one another's point of view what intelligence information, for example, can be obtained and how it can be given. We were able to understand a number of those things, and therefore to frame the kind of discussion that in a court we could not be able to do, because in court all we do is look at the evidence.
The Chief Justice has made it clear, for example, for presiding judges of court stations and counties, that they are expected to spearhead this kind of engagement in their own counties, so that when you go to your county, you don't go there and close yourself in a monastery and assume that the judiciary is physically independent. You are expected to go and engage, but while being extremely sure about your own sense of integrity and objectivity and impartiality, but also while taking every opportunity to assert the independence of the judiciary.
The Judicial Service Commission is the protector of the independence of the judiciary, to defend this institution against intrusion from the executive, intrusion from the legislature, and intrusion from interests, commercial interests, civil society interests. But we are the policy organ of the judiciary. We sit and conceive policies that will take this institution to the next level. So that even where management here includes the Chief Justice, Chief Registrar, directorates, the President of Court of Appeal, PJ, Principal Judge of the High Court, they constitute management. Now, when they will make proposals to us on policy initiatives that they want to be able to take the judiciary to the next level. It is us who will own and conceive it into a policy document to be able to issue to the judiciary.